All right. Which best describes an allergen? Is that A, the condition of water or soil which contains a sufficient amount of alkali substance to raise the pH above 70? B, relating to and or sand deposited by flowing water? C, a substance that causes an allergic reaction in individuals sensitive to it? Or D, the capacity of bases in neutralized acids? So which best describes an allergen? We've got A, B, C, or D. E. Okay. C is correct. Good job. A substance that causes an allergic reaction in individuals sensitive to it. Very random question, but there will be random questions like this on the test. Okay. Oh, cool. Let me this a little bit bigger. Okay. A seller completes a property disclosure form and states that there are no conditions in the property in need of repair. However, the listing sales agent recognizes the early signs of termite infestation. The listing sales agent should A, disclose this to the buyer as a latent defect, B, not tell the buyer and rely on the seller's statement in the property disclosure form, C, disclose the condition to the buyer as this is a patent defect, or D, tell the seller to amend the property disclosure statement. All right, we got A. Cool. So the correct answer is C. Okay, these are tricky, both patent and latent defects. So it would be C, disclose the condition to the buyer as this is a patent defect. So patent would be discovered in an inspection, and then latent defect is going to be one that could not have been discovered by a reasonably thorough inspection before the sale. So patent you can discover in an inspection, and latent you can't. I'll put this in. This is super helpful. And that was a tricky question because hopefully your inspector will be able to see this, but without the thorough inspection, you wouldn't know that there would be early signs of termites. But the fact that they named it is basically the best answer would be patent defect. That was a tricky one. Okay, next question. Ecology is best defined as A, exposure of a non-human organism to a stressor, B, the effect a man-caused or natural activity has on living organisms and their non-living environment, C, the relationship of living things to one another and their environment, or D, maintenance of ecosystem components and functions for future generations. Wow, very random question. We got allergies and we got ecology. All right. I also think it's D. Okay, so it is C. The relationship of living things to one another and their environment. Okay, good to know. Relationship of living things to one another environment is ecology. Yeah, very weird question. That wasn't on my exam, but just in case, that's what ecology is. So basically, they're just saying ecology, similar to, I guess, us living on a planet. Interesting. Hopefully, not all the questions are like this. Okay, so while touring the property during a listing presentation, the salesperson observes problems involving water penetration and mold growth. The salesperson should A, discuss with the sellers their duty to disclosure what they know about the problem to prospective buyers. B, refuse to accept the listing. C, recommend that the property be listed as is and proceed under the theory of caveat emptor. Or D, require the seller to make all necessary repairs before offering the property for sale. All right, we have A. And A is correct. Good job. So discuss the seller, their duty to disclose what they know about the problem to all prospective buyers. Definitely want to disclose anything and everything. Okay, next question. A buyer's agent is showing buyers a property for the first time. The buyers ask the agent if there is any dampness in the basement. The agent responds, to my knowledge, there is no dampness in the basement. The agent would be guilty of A, nothing, as the agent is representing the best interests of the seller. B, breach of the listing. C, misrepresentation. Or D, fraud. This is a tricky one. Oh, I was going to say A too. All right, so it is C, misrepresentation. Fraud is an intentional misrepresentation, while misrepresentation can be inadvertent or negligent. Okay. The agent did not intentionally lie to the buyers, but was negligent in not actually viewing the basement before making the statement. In this case, the agent is representing the buyer and should be looking out for the buyer's best interest. So basically, the buyer's agent should have confided in the listing agent to see if there was dampness in the basement. Instead of just saying no, they should have checked to confirm if it was yes or no. Or the best response to that is, I don't know, let me find out for you. So this would be an example of misrepresentation. The flat or nearly flat land along a river or stream covered by water during a flood is called A, fossil fuel, B, fluoridation, C, floodplain, D, flume. All right, we got C, and C is correct. It would be a floodplain. All right, good job. Next question. A listing agent is showing a buyer a home. The buyer sees a large crack in the wall that is seeping water. The buyer buys the property and later sues the agent for non-disclosure of a property defect. The agent A is not liable under the doctrine of caveat emptor. B should have instructed the sellers to hide the defect behind paneling or boxes. C is liable for damages because they did not tell the buyer about the crack. Or D should have fixed the crack prior to showing the property. All right, we go C. Okay, so it would be A. It is not liable under the doctrine of caveat emptor. So this Latin term means buyers beware. So if the buyer saw the crack prior to purchasing the water, I mean prior to purchasing the house, then they can address it and potentially have either like lower their offer or have the seller fix that prior to moving in. But in this case, it doesn't really give you much detail, so it's kind of hard to gauge what the best one is, but the buyer is not able to because they're not liable under the doctrine of buyer beware. Oh, that's about everywhere. Okay, next question. Which term best describes any substance that can cause or aggravate cancer? A, catalyst, B, carbon monoxide, C, carcinogen, or D, carbon tetrachloride? Oh, what topic is this? I'm gonna say B. Correct. It is C. I heard you. All right, so it would be C, carcinogens. All right. Good job. Yeah, that was a tricky one, but from past questions, I remember that BC carcinogens is going to be the substance that cause or aggravate cancer. All right, next question. Which term best describes reducing the degree or intensity of or eliminating pollution? Is that A, aeration, B, activator, C, absorption, or D, abatement? So which term best describes reducing the degree or intensity of or eliminating pollution? No, these are kind of hard and random. All right. That was hard. I did not know this one. So abatement is reducing the degree or intensity of or eliminating pollution. Interesting. I did not know that. That was a tough one. Yeah, these questions are hard. So property condition and disclosures. I think this is under your practice and principles portion of uh your coursework, but yeah, these are out there. Okay, this is actually a one that may be on the test. So what was the primary reason asbestos was used prior to our knowledge of the health risks? So what was the primary reason asbestos was used prior to our knowledge of the health risks? So now asbestos is obviously not used anymore, but we used it for A, fire resistance, B, none of the answers given, C, water resistance, or D, repelled common pests. A, fire resistance is correct. Good job. All right. Well, good. I'm glad that topic's over. Well, let's see. Dashboard. Back to dashboard. All right. So I'm just going to scroll through and then feel free to put in the chat if there's a topic that you want to discuss or having questions on. Any topic? Okay, sounds good. Okay, we just did property condition disclosures. Let's go to, where was it? Practice of real estate. Okay. By which system can real estate brokers share listings and commissions on listings sold jointly? Is that the A, PMI, B, MLS, C, MIP, or D, APR? All right, we go B. Cool. That is correct. The MLS, when you guys pass your exam, is going to be your best friend. Great website. Okay, so a property manager opened an interest-bearing account in which to put rents and security deposits. Funds will also be paid out for contractors who perform building maintenance. Who gets the interest on the account? Is that A, the listing broker and listing agent, B, the owner, C, the tenant, D, the listing broker? All right, we say D, the listing broker. So it would be B, the owner. So this one was tricky because normally they're talking about a broker's non-interest bearing account, whereas this one they switched it up and did a property manager. But normally it would be the broker in general. But unlike a broker's non-interest bearing account used to deposit earnest money, a property management account can earn interest and the interest being paid to the owner. Yeah, that was tricky. So to know for the test, brokers have non-interest bearing accounts, whereas if a property manager did, the interest would be paid toward to the owner. Okay, next question. Robert ran a full page ad to feature all of his listings. In one ad, Robert describes the property as being perfect for empty nesters. Robert's ad is A, will attract high quality buyers. B, should please the owners. C, is likely to get a quick sale. Or D, is potentially violating fair housing law. All right, we got D, and D is correct. The ad could be perceived as no kids allowed, which would be a potential violation of the Fair Housing Act under the basis of familial status. All right, good job, guys. That was tricky. They do have, I remember there being a question similar to this on the exam as well. When buyers ask for help understanding the various ways of taking ownership slash title, the agent should A, advise the buyers to find out how other family members took title. B, advise the buyers to ask their attorney. C, explain that married couples usually want a survivorship clause so that they can avoid probate court. Or D, give all the details known about the different co-ownerships. Okay, we got B, and B is correct. Good job. So to advise legal counsel, describing methods of ownership is practicing law. Good job. Description there. Cool. All right. Grace is the agent on Grace is the agent on the floor and receives a call from a potential buyer stating that they are an executive of a company and would like to see high-end condos listed by her firm. Grace sets an appointment and shows the executive the condos. The next day, Grace receives another inquiry on the same condos. She detects an accent and presumes the caller is from West Virginia. When the caller requests viewing appointments, Grace informs them that they will first have to be pre-qualified. Of what law is Grace in violation? A, Grace is not in violation of any law. B, Civil Rights Act of 1866, discrimination based on ancestry is illegal. C, Equal Credit Opportunity Act. Or D, Fair Housing Act, discrimination based on ancestry is illegal. B is correct as well. Good job. Yeah, that was a hard one. You're correct. So Civil Rights Act of 1866, discrimination based on ancestry is illegal. Agents should ask the same qualifying questions to all home seekers. And you want to make sure to get everybody pre-qualified so that you know how much they can spend and what they can afford in a house before you start taking them out to look at houses. All right. Salesperson Sue has just completed a purchase and sale agreement with Bob, her client, in order to make an offer on a house. The agreement includes a good faith deposit of $5,000 in the form of a check, which Bob has given to Sue. Absent any specific instructions in regard to Bob's check, Sue should A, give the check to her broker to deposit in the broker's trust account once the seller has accepted the offer. B, give it to the seller to hold until closing. C, deposit the check in her personal savings account. Or D, turn it over to her broker immediately. All right, good job. Yep. It would be D, turn it over to her broker immediately. Good job, guys. A real estate agent assures a buyer that a home is free from any structural defects. As it turns out, the home has a very leaky basement. Which statement is true? A, neither the sales agent nor the seller is liable. B, both the sales agent and the seller are liable for misrepresentation. C, the seller is not liable for any misrepresentation as the sales agent was the individual who misrepresented the condition of the property. Or D, the agent is not liable as they are just an agent of the seller. All right, we said B. And B is correct. Both the sales agent and seller are liable for misrepresentation. They both have the due diligence to, or the responsibility to disclose everything and anything that is a defect in the property, especially structural. Okay. Jim agrees to list his cousin's property. Jim shows a buyer client several properties, and the buyer client decides to make an offer on Jim's cousin's property. Jim declares dual agency. What else does he need to disclose? A, the relation between the agent and seller. B, previous sale price of the property. C, that redlining is illegal. Or D, patent defects. Patent defects. That is correct. It would be the relation between the agent and the seller. Good job. Right. Thanks. A potential buyer asks an agent whether a general warranty deed or a quick claim deed is better. Which is the appropriate response from the agent? Is that A, general warranty deed, B, a special warranty deed, C, a quick claim deed, or D, the agent may not answer this question as it involves the unauthorized practice of law? Good work. Exactly. Literally any question that I feel like has that as the answer, it is the answer. Anything that has like attorney or law and you're like questioning if this is a legal question, it probably is. So that's probably going to be the answer. Attorney, practice of law, seek an attorney. Good job. When a buyer gave salesperson Sue a check for $1,000, an earnest money deposit in a as $1,000 as an earnest money deposit in a transaction, she deposited into her special trust account. Can her client earn interest on this deposit? A, no, her broker deserves the interest. B, no, only brokers may have trust accounts. C, yes, an agent must always act in the client's best interests. Or D, no, the account must be non-interest bearing. All right, we have B. And B is correct. Good job. So no, only brokers may have trust accounts. Correct. And brokers' trust accounts are non-interest bearing accounts. So the best answer is no, only brokers may have trust accounts. And then knowing that brokers' trust accounts are non-interest bearing, so they did try to trick you by putting that in there as well. So good job just reading and then finding the best answer for the question. Okay. Gosh, these questions are long. A listing agent notices the property they are listing needs some cosmetic attention. Rather than bother the seller with the core of cleaning and making minor repairs, they advise the owner to list lower than market value to get a quick sale. The property is on the market for several months, and now the listing agent is offering the seller a list price offer. The agent has the house cleaned and does some minor repairs. The agent sells the property at a profit of 25%. Has there been a violation? A, no, the agent is doing the best thing for the owner. B, no, the agent is taking advantage of an opportunity. C, no, the seller could have done the repairs and cleaned. D, yes, the agent is self-dealing. We say D, yes, the agent is self-dealing, and that is correct. Honestly, just reading the question, it's exactly what he's doing. So the listing broker is obligated to advise the seller of the best marketing strategies. If you're going to be the listing agent, then you're definitely going to want to tell your seller the best marketing strategies before you put the listing on the market. Just to cover up, just to cover up those items. If they say they don't want to do it, understandable, but definitely letting them know that these things should be done before they list their property. They're coming to you for advice, so definitely giving it to them the right way and not obviously self-deal like this, which is not grounds for revocation or suspension of a license. A, violation of the code of ethics. B, violation of the canon of ethics. C, violation of the Federal Fair Housing Act. D, violation of the Civil Rights Act. So which one is not grounds for revocation or suspension of a license? This one's tricky. All right, we say B. You were all right, but it was going to be code of ethics, not canons of ethics. So the code of ethics is set of voluntary rules of conduct promulgated by the National Association of Realtors. All right. So that, yeah, that's confusing. So the code of ethics are the voluntary rules, whereas the canon, Federal Fair Housing, and Civil Rights Act are can all affect your license, whether it be revocation, suspension, void. That was hard. And not so know that which is not grounds for revocation or suspension of a license, it's going to be the code of ethics. Okay. If a client's earnest money check upon being deposited in the broker's trust account is returned for insufficient funds, the broker should A, resign the agency, B, tell the cooperating broker that the check bounced, C, call the police, or D, cover the bad check personally. Call the police. Correct. It's going to be B, tell the cooperating broker. Good, Paul. Okay. Marty, a real estate agent, has been trying to persuade his friend Bill to buy a house instead of renting. Marty suggests that Bill just move out as his landlord has a duty to mitigate the damages by trying to find another tenant. Bill moves out and purchases a property listed by Marty. Bill is sued by his former landlord who wins a judgment for the unpaid portion of the lease. Whose fault is this? A, Bill's landlord, B, the property owners, C, Marty's, or D, Bill's for breaking the lease. We say C, Marty's, and that is correct. Marty cannot induce the breaking of a contract to induce a sale. So Marty was just giving all of that advice in this one. Okay. A real estate agent is authorized to prepare A, pre-printed lease agreement for the seller to sign, B, pre-printed land contract form available through a legal publishing mart, C, pre-printed real estate sales contract from provided by the local bar association, or D, real estate sales contract. So a real estate agent is authorized to prepare what? Wow, this is tricky. I thought it was going to be A or D. A pre-printed real estate sales contract form provided by the local bar association. The second half of the question seems wild. Okay. Well, an agent may fill in the blanks of a real estate sales contract. It must be on a pre-printed form approved by the bar association. Oh, good to know. Yeah, this does make sense. They try to trick you by putting local bar association. My mind immediately went to like an actual bar, not like the bar. But yeah, so pre-printed real estate sales contract, you can't create your own contracts. That has to be done by a lawyer or attorney or whatnot. So it would be C. All right. Let's see another topic we can cover. Yeah, that was a good job, guys. 15 questions. We did good. Right, let's do. Let's see, which one do we not do a lot of? Okay. Okay, let's do property ownership. Mm, Honestly, the test has every section on it. I'm trying to think, looking at that, I feel like a lot of it was property ownership, market valuation, transfer of title, contracts. There's a little bit of calculations, but not a lot of calculations when it comes to the various sections that were on the test. But I'll definitely let you know guys know similar questions that I had on the test that we're going over now as well. And I'll include my study guide in the chat when we're done with study session. But yeah, I feel like they do a good job of covering all topics in the test. Which is not limited common area? Is that A, foyer in a unit, B, patio of a unit, C, unit the manager lives in, or D, assigned parking? So which is not limited common area? Okay, we got A. A is correct. Good job. The foyer in a unit is part of the unit and not common area. Good job. Which is necessary to create an easement by prescription? Is that A, all of the answers listed, B, hostile and adverse use of the land, C, constant regular use of the land for the stated prescription of years, or D, open and notorious use of the land? So which is necessary to create an easement by prescription? Got C. So C is correct because they are all correct. Actually, I forgot about that one. So yeah, so easement by prescription can be created by hostile and adverse use of the land, constant regular use of the land, stated by prescription of years, or open notorious use of the land. It's usually all, yes, good, agreed. So each element listed is required to obtain an easement of prescription. Absent of any of these, easement by prescription would fail. Yes, it's usually gonna be, say, all the above. A telephone company has 20-foot wide easement across Farmer Jones' land on which telephone poles are installed and through which telephone wires extend. When the telephone company goes cellular and removes the poles and wires, the easement terminates due to A, merger, B, abandonment, C, release, or D, failure of purpose. All right, we do D. And D is correct. Good job. Easements, easements terminate due to failure of purpose. When the purpose for which the easement was established no longer exists, then that is when the failure of purpose comes into play, where it terminates by release when the beneficiary of the easement executes the document relinquishing the legal right. So the key word for this is terminates. The easement terminates due to failure of purpose. Okay. Which is considered real property? Is that A, light fixtures, B, area rugs over a hardwood floor, C, implements, or D, tenant fixtures? C, implements? Oh, crazy. I was going to say C, implements as well. Light fixtures are considered part of the home, making them part of the real property. Implements are tenants' crops, which are allowed to be removed. An area rug hardcore is not a fixture. Hmm. I feel like you could remove the implements once they grow, but so I guess the best answer is going to be light fixtures, but depending on where the implements of the crops are, that could also be one. Oops. So it is going to be light fixtures. Those are real property and normally stay with the property. A buyer is considering purchasing an interest in a timeshare. The buyer is offered the right to buy stock in a corporation that owns the property. They will receive a lease of its units for their timeshare interest. This is a blank timeshare. An A, cooperative timeshare, a B, condemnation, C, land contract, or D, condominium. All right, I think I did have a similar question to this on the test. And you guys are both correct. It's going to be a cooperative timeshare. So key thing is the right to buy stock in a corporation. Anytime I saw stock in a corporation that owns a property, I think of cooperative. And then anything that has like a common area is going to be probably condominium. And then the other two are not related to ownership. All right. An owner of real estate sold the same parcel of land to two different buyers at the same time. When both buyers meet at the property, they discover that they both have recorded deeds for the property. Which type of lawsuit will they file to determine who has title? Is that A, action to recover title, B, civil rights lawsuit, C, quiet title action, or D, eviction lawsuit? Yeah, that sounds tricky. All right, we have A and C, quiet title action, A, action to recover title. Okay, so A first, let's see. Okay, so it would be C, quiet title action. An action to recover title may occur if a condition in a deed is violated. A quiet title action is a lawsuit to determine who has title. All right, so determine who has title, the lawsuit would be a quiet title action. The heirs of an estate are selling their deceased father's home. They remove a bedroom set, an organ bench that matches a built-in organ, a television, and various famous paintings. Which would be considered real property? A, bedroom set, B, organ bench, C, famous painting, or D, television set? What do we say? B? And B is correct. The organ bench would be considered real property since it was built to match a built-in organ. The key thing is they tell you about the built-in organ, so that automatically becomes real property. So anything normally associated with that built-in is going to be considered real property. When an interest in real property is a remainder interest, is that A, grantor is conveying legal title to grantee, B, a grantor gets title back at the end of a life estate, C, the life tenant gets legal title, or D, title goes on to someone at the end of a life estate. These are kind of tricky, but definitely knowing the difference between remainder interest, life estate, and all the differences there. I forget how they say it, but will be very helpful when answering these types of questions. Okay, we got C and D. When an interest in real property is remainder interest, so a future interest that becomes possessory when a life estate terminates that's held by someone other than the grantor of the life estate. And D is correct. Title goes on to someone at the end of a life estate. Life estates involve one or two types of future interests. One, if title goes back where it came from, the interest is reversion. So if title goes back to where it came from, it's reversion. And if title goes on to someone who has never held title, it's remainder. Well, that's a good way to describe it. Definitely knowing that will be very helpful for the test. Next question. Which would serve as evidence of a shareholder's exclusive right of possession of property owned by the shareholders' cooperation? Is that A, net lease, B, deed, C, gross lease, or D, proprietary lease? So which would serve as evidence of a shareholder's exclusive right of possession of property owned by the shareholders' cooperation? I'm thinking A or B. All right, let's say A. Okay, so it is D, proprietary lease. The net lease and gross lease are leasehold estates. Deeds convey legal title, and shareholders do not have title to the property. They live in when their right of possession occurred as a result of acquisition of stock. Okay, so stock, cooperative, stock and cooperative timeshare or cooperation, as well as shareholders of a cooperation, is going to be the proprietary lease. Definitely we'll have questions about that too on the exam. Okay. Wayne grants Brent the permission to use Wayne's property to fish on one hot summer day. This is referred to as A encumbrance, B encroachment, C license, or D easement. All right, we're gonna say C license is correct. A license is not an encumbrance. So a license, permission to use the land of another is a license, which is revocable by the grantor at any time. All right. Good job. That was a tough one. What did we get? Those are hard questions. Okay, let's see. Let's do transfer of title. 5 minutes left. We can squeeze this in. Well, perfect. 5 questions. Cool. A buyer is required to pay which closing cost? Is that A, conveyance fee, B, real property transfer fee, C, title insurance, or D, transfer tax? Definitely a need to know for the exam. Title insurance is correct. Good job. Buyer is required to pay this at closing costs. Cool. Next question. Title is best described as A, a leasehold estate, B, ownership of land, C, insurance that guarantees one owns the property, or D, a document transferring a grantor's interest in real property. So title is best defined as what? So it is going to be B, ownership of land. That is tricky because title is also a document as well. So title means ownership. A grantor's interest in real property is transferred by a deed. Title insurance will guarantee one owns the property or has title, but it is not title itself. And a leasehold estate is real property conveys possession. So a document transferring a grantor's interest in real property is the best definition for a deed, whereas title is the owner of land. The owner of land is going to be the best definition of title. Upon the completion of real estate sales transaction, a comprehensive accounting of all funds must be approved by the buyer and seller. This accounting is called A, full disclosure statement, B, settlement statement, C, statement of APR, or D, transfer and sale statement. Similar question will probably be on your exam. I think it's B or C. Okay, so it is gonna be the settlement statement, also known as closing statement. So this is called a settlement statement and in federally related transactions will be on the closing statement form. A statement of APR is when a lender, per the Truth in Lending Act, gives the buyer a disclosure of the annual percentage rate of interest, which expresses the rate of interest plus the cost of the loan in terms of the percentage. So definitely the statement of APR is going to be found in throughout the process. But when it comes to both funds of the buyer and seller, that is going to be a settlement statement on your closing statement form. That was tricky. Okay. The sources of law that affect real estate property and activity are A, all of the answers listed, B, state and federal legislations, C, local ordinances passed by towns, cities, and villages, or D, court decisions. So the sources of law that affect real estate transaction activity are. All right, I got A. Good call. Yep, and that is correct. Which is not essential to a general warranty deed for real estate? Is that A, covenant of season, B, legal description of real estate, C, signature of the seller, or D, signature of the buyer? And definitely knowing what is required on a deed is going to be on your exam. Good job. Signature of the buyer is not essential. And the question rationale is very helpful. All right, good job, guys.